Adjournment request, if any, from item number 1 to 5, from item number 6 to 10.
With respect to item number 9, may I please that matter may be taken some other day.
I have response number 1 to 12.
The writ appeal filed by the Home Ministry.
Yes. Tell one thing. This appeal against this reviewing order has already been dismissed.
No, Lordship, here what happened on Ministry of
Sir, how the Union of India, the departments are filing different appeal?
no, Lordship, what happened here, Lordship,
Ministry of Defense Estate has challenged that order.
they filed writ appeal saying that they are not liable to pay
But
compensation.
sir, the department is Union of India, the Union of India, both are the departments of Union.
No, Lordship, what happened here, there is a conflict between the two departments because the
Sir, conflict between the two departments, then why you have not argued before the this?
Lordship, in this case, Lordship, humble summary, Lordship, the notice was not properly served on the Home Ministry. Okay. And then matter was decided by the
Notice of what?
or writ appeal filed by the Ministry of Lordship, Finance Lordship.
This is actually a bit bizarre that the two departments are filing separate appeals.
Lordship, here the
Whether
direction.
you have filed separate replies before the writ court.
Yes, Lordship. Yes, Lord. Lordship, here this. Lordship, here this in this case, Lordship, normally
So
returns
first
are.
of all, you have to explain your conduct of Union of India. Two departments can file two separate appeals.
Lordship, here, Lordship, may please to appreciate that the litigation will be filed. There are two types of cases are there in state of Mizoram. One, Lordship, land were acquired by the Minister of Home Ministry separately, and they are claiming compensation the land used by the security forces during the insurgency held in the state of Mizoram. I'll place Lordship may consider Lordship next.
Okay. Mr. Kayal, can a council appearing for the Union of India pays for an adjournment in this matter? It is noticed that against the impugned order, writ appeal number 6/2024 was filed by one of the department of the Union of India, that is Home Department, and that writ appeal has already been disposed of, whereby the impugned order passed by the learned single judge was affirmed with few modifications. Full stop. It is very strange that the now another appeal is preferred on behalf of the Union of India through defense, which
Home Ministry.
huh?
The present appeal filed by the Home Ministry.
Home Ministry.
Lots. Ministry of Home Affairs.
That is Defense Department. Disposed of right order dated 15/5/2024. Whereby the single judge is affirmed the impugned order passed by certain modifications. Full stop. Now, this writ appeal is preferred by Union of India through Home Department, claiming that they are not entitled to pay any compensation as directed by the learned single. It is strange that two departments of the Union of India are filing separate appeals against the impugned order. Mr. Kayal is directed to explain the this situation by the next date of it, on the next date of hearing. List after 6 weeks.
Much of.
Yes,
Adjournment request from item number 11 to 23.
May I please, with the consent of the other side, I beg to mention item number 15 of today's daily list, my lord.
1-5.
Item 15, my lord. Can we adjourn the matter for today, my lord? If convenient, take up on Friday, my lord. Caveator is here, my lord.
What's wrong with the?
Yes,
You are for the
I am for the, my lord,
He is the seven highest bidder.
respondent number 7, indeed.
appellant.
Yes.
Here in the appellant. What's the wrong with the single judge order? And there is no condition in the NIT.
Yes, sir.
And even
Regarding
in the pre-bid meeting also, this has not been explained.
Yes.
What's wrong in that?
My lord, that
And he is the
pre-
seven highest bidder, Lord.
and the, my lord, pre-bid meeting has been set aside by the honorable single judge, my lord. That was not under challenge also, my lord. There are some, my lord, grounds.
What was not understanding?
My lord, the pre-bid meeting, my lord, which was set aside by the honorable.
Set aside pre-bid meeting, in fact, no such pre-bidding
Yes,
is
Lord.
held.
Yes.
There is the question of setting aside that. There is no proof that any such pre-bid meeting was ever held or called.
My lord,
They are the
that was-
statutory body, Lordship.
But
They
they
ought
have-
to have some minutes, Lordship. There is no minutes regarding the PEP.
only, my lord, take up on Friday, my lord,
Next week.
next week. my lord.
Don't have any advantage. What about this, whether they issued a new tender or not?
No, Lordship, till then. They have now running the market by giving the to
Why, the Leonard Singh has already given a direction.
within 3 weeks, Lordship. 21 days, I think tomorrow,
Uh,
3 weeks, Lordship, they have given.
There are.
Now
time-
they have given.
Request of the Leonard concept होता. Appellant. Matter is adjourned for a week. However, it is made clear that no stay is operating in this matter.
My lord, highly obliged. Obliged, my lord.
May I please your lordship? Lordship, take the concern on the other side. I beg to mention item number 14, lordship.
1-4.
Yes, lordship. Engage counsel out of station, lordship. Kindly adjourn matter.
Here it is not. 4 weeks.
Obliged, lordship.
From item number 24 to 28.
May I please, my lord? With the consent of the parties, I beg to mention item number 24 and 25, my lord.
Adjourned.
Obliged.
Your Lordship, with the consent,
September.
Obliged.
of the other side, your Lordship, I beg to mention item number 26, your Lordship.
6.
Your Lordship may grant 2 weeks time. Your Lordship, to
Adjourned.
file a
September. It is nothing.
Any other request?
Let me lordship, ma'am. I crave your lordship's indulgence to make a mention of the matter not in the least, my lord. This is the matter in which, my lord, the proposed deduction from pension of a retired member of this honorable High Court judiciary that was moved, and your lordship was pleased to pass an order on 14th of this month, staying the impugn orders. And after that, my lord,
Which matter you are?
my lord, by retired Justice, my lord, D.N. Chaudhary, my lord, the matter in which he had received letters from the pension authority demanding deduction of amount from his pension, saying that that was paid to him in excess.
Yeah.
Your lordship had interfered with that, passed an interim order on 14th. Now, on 16th evening, my lord, they give us a letter which he received on 16th evening, in the afternoon, saying that that money has already been deducted 2 days after the.
You are for?
I'm for the petition.
So what do you want now?
My lord, we have filed an IA today, my lord. But if that can be
Ask
taken.
the register will get it listed. Register will get it listed. Ask the register.
No, sir.
Request, and I made a request before the register, then
Fine. Not so.
Daily list for orders item 1.
No, it's regarding regulation of university law college lecture.
pass the stay order.
Your hearing date may be fixed, my lord.
The hearing finally,
No, entire matter may be hard, matter, Lord. A date may be fixed, man.
the matter comes upon for consideration of the IA number so and so. With a prayer to say the effect and operation of the impugned judgment and order dated 15/12/2022 passed by the learned single judge in the petition number 5333 of 2015. On 27/11/2024, this court has already ordered for staying the effect and operation of the impugned judgment passed by the learned single judge. Stop. It appears that we are of the view that the ground stays in the IA. In the present IA are almost similar to the ground stays in the writ appeal number 310 of 2023. Hence, it is appropriate to list this petition, list this writ appeal number 310 of 2024 to final hearing in the month of August.
Most of us.
The IA is disposed of. The impugned order passed by, the interim order passed by this court on 27/11/2024 is made absolute till final disposal of the
Hardly that.
August. Yes.
Item number 2.
May I please, your lordship? This is a condemnation petition, my lord, delay condemnation. That 230
Bill was
days,
filed in the year,
my lord,
bill was filed in the year,
2016, my lord.
now it's almost 9 years.
9 years, but the case is not listed, my lord, for
Why not listed? What efforts you have made for that? 9 years, this condemnation application is pending. What is this? And the advertisement is of the year 1996.
my lord.
Now you are seeking appointment in the year 2025.
But the case record was something somewhere misplaced in the filing section, my lord.
What, if it was misplaced, have you moved any application for reconstruction of the file?
After several attempts, my lord, now I have come.
You have several attempts, but we are sorry to say. Those attempts are not sufficient. Nothing. Mean to say that in the recruitment of the year 1996, now we'll issue an order for appointing you. The learned single judge has discussed everything in very elaborately. And in fact, learned single judge dismissed your petition, taking into consideration this fact that advertisement is of the year 1996 and now it's 2014-15. No such order can be passed and now 10 years, again 10 years have passed. Okay, the matter comes upon for consideration of the IA number so and so. With a prayer to convene the delay of 230 days in filing the connected writ appeal. Stop. Though this court has issued notices to though this court has issued notices to the applicant, to the respondents who had appeared on 25/11/2024. However, after going through the facts of the case, we are of the view that there is no merit in the connected writ appeal which is yet to be registered, for the reason that the applicants herein as preferred and writ appeal, writ petition number 5823/2014, along with 5 other persons with a prayer for issuing a direction to the respondents to select and appoint them in connection with the recruitment notification issued in the year 1996. For the post of, what was the post? What was the post? The recruitment was for which post? Even the appellants have also forget that for which post they have applied for.
Oh, my lord. Actually, I am not prepared for the main case hearing today. my lord.
We are prepared. You just give us the,
Sub-inspector. 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 Sub-inspector.
Sub-inspector of,
Civil supply.
recruitment and appointment on the post of sub-inspector in the food, civil supplies and consumer affairs department, government of Assam. So the learned single judge has declined to grant any relief to the applicants while taking into consideration the checkered history of the litigation in respect of the said recruitment, wherein several orders were passed by this court in several writ petitions. Ultimately, the learned single judge has held that the applicants were not successful in the written test, and thereafter they have alleged anomalies in the examination of their question papers, question answer booklets, and this court in the last round of litigation has remanded back their cases to be considered afresh by the committee of high officials as constituted by the court, which has been noticed about to scrutinize the answer scripts of all the petitioners and of all the applicants, and thereafter to pass speaking orders. The committee was constituted with scrutinize the answer script of the petitioners and thereafter their selection. And thereafter it was found that they are not entitled for selection pursuant to the recruitment notification. The learned single judge has further observed that it is clear that the original marks obtained by the candidates were erased and new marks were inserted with a nullified intention to give undue advantage to the candidates. The learned single judge has ultimately recorded a finding that when the marks awarded to the applicants were manipulated and tempered, there is no question of calling the applicants for viva voce test. The learned single judge has held that the applicants were not successful in the written test, and thereafter their selection. Ultimately, the court in the last round of litigation has remanded back their cases to be considered afresh by the committee of high officials as constituted by the court, which has been noticed about to scrutinize the answer scripts of all the petitioners and their applicants and thereafter to pass speaking orders. The committee was constituted with scrutinize the answer scripts of the petitioners and thereafter their selection. The learned single judge has also observed that the first advertisement was issued way back in the year 1996. That is more than 19 years before the passing of the impugned, before passing of the impugned order. And therefore, when the petitioners, when the applicants were not successful in written tests, and their cases have been examined by this court at length in two previous round of litigation. Wherein the high power committee constituted has gave a finding that the question answer booklet of the applicants were vitiated on account of tampering and manipulation. This is the high time to brought the litigation to an end. This also to be noticed that after passing of the impugned order dated 10/9/2015, almost 10 years have passed. And there was no attempt on the part of the applicants to get this IA listed till November 2024. Taking into consideration the overall facts and circumstances of the case, we are of the view that no useful purpose would be served in keeping this IA as well as the connected with appeal pending, hence the same are dismissed, particularly looking to the facts and circumstances of the case.
Obliged, man.
Item number 3.
Similar matter, lordships already condoned it.
Number of days. Yeah, 415 illegal 199 days.
Much obliged.
Yes.
Item number 4.
We are not pursuing this appeal. Malad. The similar appeal has already been dismissed by the other court. We are not
Okay,
pursuing
then let's consent for the petitioners. Applicants have submitted that since a similar appeal has already been dismissed by the coordinate bench. They are not pressing this IA as well as the connected.
Okay.
Let appeal.
Gotcha.
Dismissed.
Obliged.
We have the submissions made by the constitution.
Gotcha. Obliged.
Item number 5.
May please, your lordship. Lord, this IA has been filed.
There is no response. Who is appearing for the Sikkim, state of Sikkim? Who is appearing for the state of Sikkim? Madam, you are appearing for the state of Sikkim?
No, your lordship, I'm appearing for respondent number 1 to 10, your lordship.
Have you filed any counter to the application?
Your lordship, while going through the petition, IA application filed by the respondent, your lordship, I went through that and I did not think it necessary to file my reply, lordship, because I will be arguing on Lordship, I'll be verbally arguing on that application.
If you are not in requirement of filing any reply, please.
Yes.
Who is for the state of Sikkim? Pass over the timing, call it.
Yes,
Last occasion it was H. Burgoyan,
Burago, my lord.
Buragoan.
He appeared.
Who is he?
Yes, I'll just check, my lord. I'll call him.
Pass over the timing.
Yes, much obliged.
Item 6.
In the connected writ appeals, the lordship was pleased to pass this order, my lord, allowing us to implement the original writ petition number 125. My lord, lordship will pass this order, my lord.
Your petition is not 125.
No, the origin, this petition is 5689. There are 5 petitions filed, my lord, and same judgment order was passed. So we'll implement the petitioner in the petition number 125 in 5689 of 2007.
The petition number
5689 of 2007,
2007.
lordship.
Please go. Please implement it. 5689 only 2010.
Yes,
Please start the 6 weeks.
lordship.
Item 7.
An application has been filed.
Do you have any objection?
No objection.
If the matter comes upon for consideration of the IA number so and so wherein Lanet and the concept of the wherein it is clear that on account of death of respondent number 4 and 5, their legal representatives be substituted in place of them. Would stop. Lanet concept of the applicant has no objection, the respondent has no objection. If the legal representatives of respondent number 4 and 5 of the connected writ appeal number. What is the number of writ appeal?
Writ appeal not yet numbered. It's in the delay stage.
188/2025.
Filing number is there.
Filing number.
Filing number is there.
Filing number.
Filing number.
Filing number, we substitute this, full stop. Hence, the application is allowed. The that Shrimati Sabitri Goswami and Shri Neeraj Bhardwaj be substituted in place of the respondent number 4 and 5 of IS civil number 485 public 2025 filed in writ appeal number 188/2025 filing number as well as in the above referred writ appeal. Amended cost will be filed within a period of 1 week.
Right.
On filing of the same may be placed appropriately on the court.
Right.
Item number 8.
May please. Well, is the appeal preferred by the state, my lord? While preferring the appeal, there is a delay of 385 days, my lord. It has come for the first time, my lord.
My lord, I'm appearing on behalf of the for respondent SSA, my lord.
Respondent?
Service examination.
Service examination, my lord. My lord, a copy of the writ appeal along with the IMA furnished to us, my
Writ
lord.
appeal still it is, writ appeal is not registered. Sarva Shiksha Abhiyan.
They're all together, my lord. Yeah.
What was the Leonard Singhal, this is passport order?
Page 137, my lord, the ground for appeal, my lord. The learned single judge has held that, my lord. Last line of first paragraph, there is no requirement under the said act to have verification of dice code after 2019. We have rejected the provincialization of the petitioner on the ground that they have not, their dice data have not entered in the year 2011-12, my lord. And learned single judge has held that there is no requirement of having a dice data for the year 2011 and 12.
Notice the year number so and so. Mr. So and so is appearing on behalf of the respondent.
Appearing on behalf of my lord.
SSA, my lord.
Respondent number
Number
20, my lord. 20. 20.
20, that notice will be issued to the other respondents. Through registered AD and the state returnable.
1 to 18, my lord. 1 to 18, the private respondent.
1 to 18.
18. 1 8.
And what about 19?
19 government, my lord. The deputy commissioner, my lord.
So and so is appearing on behalf of the respondent number 19. That notice will be issued to the respondent number 1 to 18, returnable 6 weeks. Registered AD the state requisite within 1 week.
My lord. What is it?
The copy of the IA as well as the connected with appeal be supplied to the council for the respondent number 19 and 20 within a period of 1 week.
Obliged.
My lord.
Item number 10.
Lordship, 10, 11, 12 are same matters, batch matters. I request Lordships to take 12, Lordship, because 12 is the main lead matter.
First of all, 12, in item number 10, what is the question of law?
Lordship, 10
It's
is
the question of.
question of law, Lordship, that the Honorable Sestet has decided the matter for coolment, which is item number 12 before your Lordships. And in that, in one paragraph, it has been stated that because the allegations against coolment is proved, then the Senvet credit of Kaizen is disallowed.
Is the question of law in this item number 10?
Lordships, I am just. Lordship, page 14, serial number 1. Whether the Honorable Sestet in order dated this was correct in returning the finding that the appellant has not received the goods only on the basis of investigation of coolment and without taking into account the details of manufacture done at the appellant's end and the returns filed by the appellant.
They have taken into consideration from
Lordship,
para 16, everything they have taken.
Lordship,
into consideration.
that is what, Lordship, I will prove from records why the.
What records, sir? That is a question of fact.
Lordship,
You have produced certain returns. They have said that these returns are bogus. That is the finding of fact. While taking into consideration that this electricity consumption, the transport bills, everything they have taken into consideration, pure question of fact.
Lordship, that is serial 12. That is why, Lordship, the issue arises from a fact that from 2002, I set up a manufacturing unit. Department comes and verifies my unit. And for up to the period 2004, I get an order of refund under the benefit of Northeast.
But ultimately, they found something fishy.
Lordship, they
inquired into it.
they-
They found, they
Lord-
collected the
Lordship,
evidence.
they invoke the extended period of limitation first. They say it's a case of suppression. And they say in the Sestet in the order goes one step and ahead says that the department's refund orders are stereotype. Lordship, how can that finding be returned by the Honorable Sestet?
In fact, these question of law. we are-
Lordship, kindly take some serial 12. I will show your Lordship what is the.
Sir, first of all, one by one, come on.
Lordship, why I say 12? Because Lordship, that is the main case. These are the analogous cases. Actually, in the listing, it has come like that. At the time of filing,
In case or whatever, my order is common.
Lordship, there are,
Order is common.
Lordship, order is common, 3 separate order numbers in one order.
Order is common.
Order is common.
Order is common from prior
So-
16
Lordship,
to up to end. The Sestet has taken into consideration each and. every
Lordship, I will
evidence
show,
produced
Lordship,
by- So, either by the full mint or either by the that another.
Lordship, Kaizen, there is no observation of this estate, Lordship.
This is the.
Lordship may kindly take in that regard. Coolment, I will request Lordship to take that because I will show what are the perversity. Lordship. Lordship, first, I will take your lordship to the point of issuance of show cause under section 11A of the Central Excise Act. Lordship, the show cause was issued alleging multiple issues. First, my refund which was granted to me was sought to be recovered. And then with that, 11D was introduced. 11D stated, 11D is a provision, lordship.
2 years limitation,
Lordship, at that time, 12 months.
whatever, that time 12 months.
12 months, 1 year limit.
Where there is a suppression, fraud and something else,
Then 5 years. Then 5 years, lordship. But that, unless this honorable high court, our honorable high court has held in these cases, lordship, that unless that refund orders are a subject matter of challenge, they cannot arbitrarily initiate new proceedings because it is departments.
which refund orders?
The refund orders are under 32/99.
If the refund orders are under challenge, then they can't initiate any proceedings.
11A cannot be initiated. Lordship, this honorable. Lordship, this has been followed subsequently by the honorable division bench of the Meghalaya High Court also. judgment was subsequently relied in 2021 by the Honorable Meghalaya High Court also, Lordships. When in the same
Then you are telling that this approval or whatever the order which
For High Court passed.
this granting them the benefit of the notification, whether they are telling that. It's under section 35E.
I have to, I have not aware of it.
Having heard the learned counsel for the parties. After going through the material available on the court, we are of the view that the writ appeal, we are of the view that substantial question of law arrived in this writ petition. In this writ appeal, hence the appeal is admitted. The following substantial question of law is framed, whether the revenue can resort to section 11A without challenging the order passed by the competent authority of the central excise, whereby the SSC was found eligible for exemption under the notification dated
Lordship, notification dated 8/7/99.
notification number 33/99 dash CE dated 8/7/1999.
Lordship, I am asking for a stay, Lordships, because I've already deposited 15 lakhs. 15 lakhs out of 95 lakhs is
The
with
demand is
95 lakhs, Lordships. 15 lakhs, more than 10% was the statutory pre-deposit. I've deposited more than that, Lordships. Double of that in my Lordship, 95 lakhs would be 9 lakhs. I've already deposited 15 lakhs. It is with the department since 2006, Lordships. Lordship, may kindly grant a stay of this order.
that concept of the yes, the concept of the plant has also submitted that he has already deposited the amount of rupees 15 lakhs against the demand of rupees
Lordship, demand of rupees 95 lakhs.
demand of rupees 95 lakhs, and therefore the impugned order passed by the says that Nikanji the state. It's found. In all these three appeals, this is what the only question of law is.
Lordship, because if this is decided, those are analogous.
These are in such circumstances, the impugned order passed by the says that dated 11/12/2024 in excise appeals number so and so so and so so and so is stayed.
Lordship, these are this amount was 95.60 lakhs.
95.6. Check.
Much older. Grateful. Lordship, may I get liberty to file my compilation of judgments in the
You need that liberty.
Lordship, just
You need that liberty for you file the compilation. Who is
Grateful.
stopping you?
much of.
Item 13.
This is appealed by the revenue. Lordship, here, CSET says that you cannot, order cannot be passed on the basis of Form 26.
26 AS.
Yes, Lordship.
26 AS,
Yes,
Form 26 AS.
Lordship, but Lordship,
What's wrong with this assisted order? Whether you can pass a order
no,
or
Lordship,
not?
on taking figures from that, Lordship, definitely Lordship, authority can assess and pass necessary order.
Where is the law on this point? Where is the law?
Lordship, some judgments are there, but
Some judgments are, show us the judgment.
but
That this is the law.
CSET relied on that one
You have
judgment passed by.
simply, what is this question of law? Whether the assisted court were right in holding that the improved demand is not sustainable against the appellant on the basis of the details provided by the income tax
Yes,
department, Form 26 years. They have relied on the earlier judgments
Yes, passed by it, Lordship.
passed by this estate.
Yes, Lordship.
So whether you can raise a demand on the basis of the details provided in section 26 AS or not, show us the law.
Then Lordship may take up next week. And Lordship, regarding
For this reason, substitution question of law that you have to satisfy.
second question, Lordship, regarding Lordship limitation.
So they have simply said
There are
limitation will come later. First of all, whether you can raise this impugned demand on the basis of the details given in 26 AS, Form 26 AS or not.
that Lordship regarding,
Limitation will come later on.
there is no judgment of honorable Supreme Court, Lordship.
Sir, any other or either show from law that any statutory provision that you can do that.
Lordship, that the original authority taken into consideration that form and the analysis, because they are.
Sir, what of that? This may be, but whether it is open for you to do so or not, you have to show either from the statutory provision or any settled law.
Lordship may take up tomorrow, Lordship. I'll let you.
Then the concept of the appellant raise some time to satisfy this court regarding the substantial question of law involved in this writ appeal. This law, list of ready. Any additional matter of Mr. Sikkim, except notice on behalf of the review respondents? Is this fee for the hearing in due course? Is these appeals for hearing in due course? Yes.
Item 16.
Lordship, in item 16 and 17, Lordship, some mistake has occurred because both have been registered in the name of same person. It should have been different person. Let me
That
check up
is-
with the
Registered in the name or not registered in the name of same person?
Lordship.
Registered in the name of different person,
different person.
that is there.
One is, but in the cause his name has been shown.
कौन इसमें गलती से हो गया है? That is बाकी registered, it's registered in this.
Because the order sheet has been interchanged between the both the cases.
Registered, there is no in the, only in the causes, the title has wrongly been mentioned.
So
Otherwise, you are relying on this circular 2018.
Lordship.
When you this, you brought into the notice of this circular before the year?
Lordship, we taken day after tomorrow, Lordship. I thought the mistake, because of the mistake,
And it
Lordship.
is another matter. The order is consent order.
That's true, Lordship, that
And
was,
now
but
you're
there was
saying
no
that-
instruction, there was no instruction from our side.
Sir,
Because it's
yeah,
run,
There was a consent, yes, it is covered by so and so, and the tribunal has passed the order, either review that order
Lordship. Let it be day after tomorrow, Lordship.
after a week. It appears, it it's 16 together after a week. It appears that item 17 में करते ना, है ना? So the petition is registered with the title Union of India and others, what says the ex-sequoia newly married. But in the cause list, a different title is reflected. Registry is directed to collect the same and list this matter after.
Item 18.
Lordship, yes. Here I have challenged the order dated 4/6/2024 passed by the Central Administrative Tribunal, Lordship. And I have just prepared a note, Lordship, complying all the things just to.
You are not having this LMB and heavy motor vehicle license.
No, Lordship, the
This
thing
was
is that, first
The
exam,
advertisement in the
exactly,
Hindi
Lordship.
advertisement, this Hindi version of the recruitment notification, this condition was not mentioned, but later on they issued an corrigendum
Corrigendum.
before the last date of application.
Yes, Lordship, that I have come up, Lordship.
The condition was very much there.
Yes, Lordship, that we belong to the Hindi version, Lordship. Just kindly see the note I have prepared and I will satisfy this honorable court. There is note, sir. Lordship, this is admitted fact that first part I have written in Annexure 1, the petitioner applied for the post of so-and-so under category 50 pursuant to centralization of employment notification issued by the Minister of Railway. This is Annexure 1, Lordship. Petitioner applied for the post of assistant loco pilot technician, and thereafter the petitioner appeared first stage of computer-based test 21/8/2018 and they cleared the same. Then, Lordship, by the time 22/9/2018, the second, for example, by making correction was come up and under category 100. Thereafter, petitioners were sent equal letters for the second stage computer-based test, and they appeared on 23/1/2019 and also passed. We have made the annexure to that part. Then petitioners were shortlisted for verification of documents and medical examination, and equal letters were received on 22/7/2019. We have made annexures where it is clearly mentioned that we have satisfied that. Then, Lordship, verification documents and medical exam were done on 5/8/2019 and 6/8/2019 respectively. Before that, the petitioner deposited requisite fees and submitted their biodata in prescribed format, Lordship. Thereafter, Lordship, the petitioners awaited for the publication of final list. However, the selection list of technicians who are under category 100 was not published. Instead, endorsement was made online stating that no eligible candidate was available. Further, petitioner were never called upon to produce the documents for verification, nor was any intimation for communication issued to them in this regard, Lordship. On inquiry, the petitioner came to know that as they did not possess heavy-duty motor vehicle license, not considered in the filing list. Lordship, now it is come. The Western Railway, I have annexed the document also. The Western Railway empaneled Rohit Kumar for the post of under category 100, even having no heavy duty driving license, and he got light duty license 21/9/2020, but petitioner were denied. So, Lordship, my thing that.
So two conditions were there.
Yes, Lordship.
To possess a valid driving license for driving a light duty and heavy duty vehicles.
That's it.
What is that? Certificate.
Yes,
Show
Lordship.
us.
Yes, Lordship. The thing is that.
The certificate.
Exactly.
Dated prior to the date of note, this recruitment notification.
No, Lordship. Yes, Lordship. That here, what happened, Lordship? In additional affidavit, we have submitted, they have possessing the light vehicle 2013 and 2020, they obtained the heavy vehicle. What happened, Lordship? Kindly see, in another instance, in the same part, one Deepankar Roy, he was earlier the applicant before the center. There, the notice was served to them for verification. At the time of verification, kindly see that part. He got the notice, but we were never get any notice that
Even though if the notice was not served upon you, you just satisfy us that you are having both the licenses.
Lordship, additional affidavit, Lordship, come up, Lordship. Because that part, additional affidavit, Lordship, come. We have annexed that part. In page number 157, 158, 159, Lordship.
Yes.
We have because we did not know that we have to, that license is required.
This
is the light motor, or then 2020 we obtained the heavy vehicle also.
Date of the advertisement?
That is of the advertisement 2018, Lordship.
18 last.
Then the process was exam. last date, Lordship,
Submission of the application.
application that was, Lordship, second application was 22/7/2000. This is in second one is on 22/9/2018, second one. Revised application, the notification was on that date.
Last date for submission of application.
Last date is, Lordship, that is, have to see, Lordship, that is 1/10/2018.
1/10/2018.
Lordship.
Tell us, the requirement is that a candidate should possess this license for this light duty as well as heavy duty.
Yes, Lordship.
You show us that before the last date of submission of application, you were possessing both.
Yes, Lordship. The only one thing has to look into it in this aspect, Lordship. Can you see? We are not so much that students who are contesting here, they are ITI students. They went peruse and they will know, because as the arrangement was made in page number, kindly see the 100, that is in page number 23, Lordship, and it's page number 23 of the writ petition. So they thought under that impression, this is for another, not for the ITI. Can you see the page number 23? How it was leaked? That was the confusion arose. Page number 23, can you see, Lordship, page number 23, annexure A. Where can you see? That was the inference, that
This page number 23.
23 of the writ petition, you know, page number 23 of the writ petition.
Yes, writ petition.
Yes, sir, writ petition. That is for 100. Second time what is given, initial debit, matriculation, SLC and ITI.
Page number 23 is the list.
23 of the writ petition, Lordship, it is annexure.
A.
Yes, Lordship, this is annexure. Annexure 2 is on page number 20, and this is annexure, this is part of that page number 23. Now.
Page number 23, what do you want?
Annexure 2 of the writ petition, Lordship, not there. Yes, 100, first column 100 category, which where the petitioner applied.
Technical.
Right side, column A, annexure A.
Technical grades, third, motor vehicle driver cum mechanic.
लेकिन सब भूल से
Yes.
So above one, this is shown matriculation oblique SLC plus ITI. We have from ITI.
No problem. This is not, yes. Then,
So then it was given or and ported.
so either you have matriculation SLC or so and so, or
ITI, ITI.
okay.
Yes.
Or so and another this mushroom of SLC plus code and so and so, so and so. Either of them,
Either
you
of
are
them.
possessing and
Yes.
and should possess a valid driving license for driving light duty and heavy duty vehicles.
Exactly, yes. But that part, those applicants, they were not so much aware about those things. So, no, Lordship.
Wait, you
No,
just show us
Yes.
that prior to the last date of submission, you were possessing all these things.
I have
This
possessed
light duty and heavy duty, show us.
light duty. I have 2005 light duty. I have all the three applicants had light duty vehicles.
Fine. Heavy duty,
Heavy duty on 2020 we got it.
so after the date of
Yes.
advertisement, so
Yes.
what's wrong?
No, that will come up.
Wrong
That's it.
there.
That's it. That is now happened that on the technicality part today. What happened? One applicant, he received verification notice. At the time of verification, they were not objected. Of documents, they will cross. Medical, they will cross. In another student, one applicant, he has not approached with the call. He got the. I have served that part. They got the verification notice. That student, Dipankar Roy, he approached the state.
Forget about verification
No, look.
notice. Even though if they have not given you any verification notice and you are not being able to show, you show us from the record that you were in possession of light duty and heavy duty driving license on the last date of application.
No,
If
I
you
have
are
only the
having-
light duty vehicle.
If you are
That time,
having, certainly we'll ask them to consider.
no, Lordship, light duty I was having that time.
So that, this condition, you are not satisfying that condition,
Yes, Lordship.
then
And yes,
what's wrong in their action?
no,
Rejecting
that
your
will
candidature, sir.
come up. They cannot stand in two footing, Lordship.
What to take?
First, the thing is that they during verification and medical verification of the document, they allowed us to go. Verification of the document.
Leave it everything, what you have done, even though you just show us on the date, last date of application, you were possessing these things, will direct them.
No, Lordship. I have posing only the light weight vehicles.
So
Lordship.
you are not.
I admit it. I admit
not
that part,
a-
Lordship.
you
I
are
admit
not
that.
requirements,
Yes, Lordship.
then what's wrong
But
with that? Sir?
that is because, sir, railway, I appoint from the central railway part and the western railway, the railway has considered annexure 4, 4A, 4B, I have annexed, one Ronit Roy. Their court has given them chance, so they cannot come into a footing.
If any candidature of any person is considered, ignoring this, what right you have got?
No, sir, I have a right. Lordship, their decision of this court, this is a public department, they cannot come and that only because of that, because, Your Lordship, I have all,
Everything in.
So this court has said, that even though if the person is not possessing, appointed,
no, Lordship.
then
One thing, Lordship, kindly, I have come to the decision of the court, this Supreme Court in this regard respectively. I have kindly come to page number, Lordship. Annexure 6. Annexure 4 to 28. Come to page numbers 32, annexure 6, Lordship.
32,
32, annexure 6,
yes,
and page number 33, annexure 7. Kindly see, page number 7.
yes.
Page number 7, annexure, page number 33, annexure 7. This person who is not before the word Rohit Kumar, he appeared for the Western Railway, where his issue lies light vehicle, this heavy vehicle 29/1/2020. He was allowed. He was allowed. This is central. Let's see. What I
Ignoring the qualification
Yes,
part.
right.
Now, what right you have
No,
got?
Lordship. Yes, that is only saying, because what happened, the license matter, because under mistake of facts, I could not submit or,
Submit, you are not even possession of that heavy duty license.
yes, Lordship,
On
they
the
have
date
also
of-
not.
Huh?
This person, Rohit, he was Western Railway, he is allowed. He has also license was in 2020. We have all heavy licenses on 2020. Kindly see this decision, Lordship, kindly, I'm placing this one.
Yes.
Three decisions I have mentioned, Lordship, that 3 decisions because
Have you placed on record that advertisement issued by this railways,
yes,
Western
Lord.
Railways?
Yes, Railways.
In which this Rohit Kumar was selected?
Rohit Kumar was selected. I have mentioned that part. In my
What is the
reply,
advertisement? What was the condition in the advertisement?
Western Railway advertisement, I have not, but his
Sir,
list.
in your advertisement, there is a specific condition that a candidate should possess driving license of light duty and heavy duty vehicles. Admittedly, on the last date of the submission of this advertisement or application, you were not possessing heavy duty license, you are admitting it.
Yes, yes, I admit it.
What's wrong in the action of the this respondent and rejecting your candidature, sir?
Sir,
Even though if you have passed everything, medical examination, physical examination, written test, everything, but ultimately you are not having that position, qualification,
Exactly. Yes,
then what's
That-
wrong in the action of the?
that's why I'm submitting for it. Because that 2020 license regarding heavy vehicle I obtained on 2020.
Then
All the examinations I made for 1 year I have given. Verification document I have submitted. They have medical test. They have not asked me because other person they served notice
even though
in the
they
same
would have
case.
asked- even though if they would have asked you from where you got this heavy duty license, you have only procured that license in the year 2020.
Yes, Lordship.
Where was the selection last date for submission of the advertisement of 2018?
Yes, Lordship.
So admittedly, you are not having, at that time, you were not possessing the requisite qualification.
Yes, Lordship.
So now how the respondents can be said to be committed any illegality in rejecting your candidature?
Lordship, that is Central and Western Railway all have to follow the same principles, same rules. In that, no, Lordship, come up. I will come up before because here what happened that license other persons whom they served verification notice, this document is sought. Another person, they have given the opportunity, Western Railway, he got appointment. He got appointment. And our Supreme Court's decision in this respect, you want to kindly see that part in respect of this. Let's see the three parts. A2 decision will be the A2 debate. A2 decision given. Or A2 debate. I would take A2 debate. The first decision, Lordship, 1991 supplementary to SCC.
1991.
1991 supplementary to SCC.
Yes.
Yes, Lordship. In paragraph 2, Lordship,
Yeah.
Reliance has been placed by petitioner on the decision of Allahabad High Court and Union of India.
What were the facts of this?
No, Lordship. This Jade Sheikh case, this is Lordship 2025 STPL, Supreme Court decision, Lordship, come hearing. Hearing, Lordship, no, Lordship, kindly give.
Before the Supreme Court, what the facts of the case?
Yes, facts of the case. I'm come to this, Lordship, this paragraph number 2025 STPL, paragraph number 8, Lordship. I read it.
Sir,
BMS
this
exam.
1991.
Lordship, before that 1990, Lordship, if coming up to 1990, because Lordship, here what is said that
Sure, which judgment you are relying on?
first, Lordship, come to 1991 supplementary.
1991.
Supplementary to SCC 497,
Yes,
Lordship.
Yes. Come.
Reliance
What
has
are
been
the
placed.
facts of?
Yes, I will read it, Lordship. Reliance has been placed by the petitioners on the decision of High Court in Union of India, absent so and so. Therefore, the decision has been accepted by Railway Administration in a sense that no special leave petition was preferred in this court in matter of filer. Petitioners who are employees of Eastern Railway have contended they are entitled to the same treatment as being accorded to their counterparts in Northern Railway, pursuant to the aforesaid decision rendered by High Court, so and so, which has become final between Railway Administration on one hand and the employee of Northern Railway on the other hand. In the like command of Article 14 and 16 of Constitution, the same treatment is required to be accorded to the petitioner regardless of the fact that they are serving Eastern Railway unless it is shown that there is some distinguished features for according to a different treatment. Learned solicitor so and so. So here, Lordship, now they are to prove before this scholar court whether the document Rohit Kumar, which I have annexed as for Western Railway, whose license was valid because under category 100 he also applied in the Western Railway, whether his license was valid on the day of application. Next, Lordship, can we see? This is J in BMS, Lordship, 2025 STPL, Lordship, 3472.
25.
2025 STPL 3472
Yes.
SC.
Yes.
Here, Lordship, here the students were appear in BMS exam where his marks in English was less. He could not quite, then I'm relying on paragraph 8, Lordship. Here court is,
Just
Paragraph number 8, Lordship. Here, what I will just read it, Lordship. The interim order granted High Court has recorded that the appellant would not be entitled to claim equities. The fact that he was permitted to complete the entire course and had also finished part of his mandatory internship ought not to have been brushed aside lightly. We noted that appellant had put about nearly 6 years and then pursuing BM so-and-so, and at the result, High Court's order was discriminate his entire labor of all these years. An act of court should ordinarily not prejudice anyone. This is a fundamental principle of justice, but it was disregarded by High Court while considering the case of the appellant. In any event, the appellant's so-called ineligibility, which was not essential in context of course that he had taken, was cured by him thereafter owing to the liberty given by the college itself by previously admitting him to in the course of September. So given these peculiar facts, we are of the opinion this is a fit case where interference so that appellant is not left out and called after completing almost entire course. So my submission, Lordship, no, Lordship, no, Lordship, my
matter
no, Lordship.
where the person was allowed to continue with the course by the interim order,
Yes.
taking into those peculiar facts and circumstances, how it is applicable in the cases of employment, sir?
Lordship, this is here in my case also kindly see that part. Only the heavy license because some parts Lordship can take any decision, but the thing is that like
Sir, that we will
no,
take.
Lordship, yes, Lordship kindly see. In other case, they send you have short list of these
Okay,
documents.
Another judgment.
That's this is. Now 1979, AR 1979, 3 SCC 489 Lordship.
1979, yes.
979, 3 SCC 489 Lordship. Paragraph number 20 and 21 only.
This is
I'm really-
Raman Dayaram Shetty.
Yes, Lordship. Only paragraph 20 and 21 I'm relying on.
First come to the facts.
Yes, sir. Can you see that? Yes, corporation it would be in the best also. The rule inhibiting arbitrary action of the government which we have discussed above must apply equally before such corporation dealing with the public. Whether by way of giving jobs, entering into contract, otherwise it cannot be act arbitrarily and intend to relation with any persons. It likes its sweet will, but in
It
action must
was
be
responded by public notice.
With some
invited
principle-
Tenders for putting up and running a second class restaurant of 2 snacks bars at the International Airport, Bombay. Sir, how this is not at all relevant, this tender matter?
no, Lordship.
Here is the employment case.
The thing is that, Lordship, this is what because I was never informed that
What-
on this
about
ground
what? About what?
that my in final list when it did not come up, I made inquiry.
Even though we are giving.
They have not
liberty,
replied anything.
Even though if you have not been informed, you please satisfy us that on the last date of application, you were in possession of the requisite qualification. Will direct them to appoint.
Lordship.
Show us.
Yes, that I admit.
You
That I admit that
then matter ends
heavy
here, sir.
license was not.
Matter
with-
ends here.
But Lordship, only one thing is to be considered. Why in the Western Railway other persons has availing that
We
part?
don't know. You have to put those facts before us.
Yes, Lordship, kindly that scientific.
That
This is
this was the, and even though if a person was wrongly allowed or wrongly appointed, ignoring the requisite qualification, how you are having any right over that, sir? How you can claim at any indivisible right?
no, Lordship. This my only submission here did that. First, even during verification must complete all the test exams, all effort for more than 1 year we made it.
Sir, everything done, you just show us okay, on the last date of application, you are having requisite qualification will condone all this delay. The recruitment is of the year 2018. Even though we are ready to give a direction to appoint you in the year 2025, please satisfy us. You are admitting you are not having that qualification.
No, that is honestly, I am telling you, submission before the court. Later on, I have annexed in my affidavit because those only this is the technical where the license is required, heavy license, ITI. So, yes, no, Lordship, the thing is that I admit it. Because otherwise I would have submitted my light motor vehicles also. That was not done because nobody asked us to deposit submit. And by reading the column,
We are going
we did not
follow
notice.
this, even though they have not asked you, but the requisite qualification is this. You just and you are admitting you are not having that.
Nah, yes.
qualification. Matter ends here, sir.
Lordship, in 2020 only because light motor vehicles we have all the okay. Because here. Because I have next here the Dipankar Roy was 156. And
That's all.
that's it.
That's all. Nothing else.
Because 2019, we have got the heavy license here, 2019 or 20 lots. That is only, and what happened, Lordship, only, no, Lordship, only one case is to be, little sympathetically, that is to be considered because other conditions, suppose examination, if you fail first, second, computer aptitude test, then verification, medical, all along, he has done things, that's it. So it means when, in page number 56, Lord, come to affidavit, when they send such type of thing to other, giving opportunities, kindly see, page number 156. He is the applicant, 156, in our case also, in our case.
Suppose if they would have given you the opportunity, you could have shown them, yes, I am having the requisite qualification.
On that day, this is, I'll
That day
submit,
you will not have it.
on that date is not, but later on it is 2019. And Lordship, I submit the judgment only because that is in Central Railway, Western Railway, they have under the same part. So in this case, Lordship may kindly be,
This petition is filed by the petitioners being accused with this and order dated 4th of June 2024 passed by Central Administrative Tribunal Guwahati Bench in original application number 36/2021, whereby the OA filed on behalf of the petitioners have been dismissed. Stop. The appellants, the petitioners have applied for selection and appointment on the post of grade technician, grade 2nd motor vehicle driver cum mechanic pursuant to the recruitment notification dated 3/2018. It is not in dispute that the last date for applying pursuant to the aforesaid recruitment notification was, what was the last date?
second one, Lordship, 1/10/2018, lecture 2,
1/10/2018.
revised.
As per the notification number 1/2018 issued by the railways, issued by the, which is that railway, NF Railways.
Yes,
NF Railways for the purpose of selection and appointment on the post of motor vehicle driver cum mechanic, a person, a candidate should have possessed a valid driving license for driving light duty and heavy duty vehicles apart from their educational qualifications. Admittedly, the petitioners were meeting the requirement of educational qualifications, but they were only in possession of a driving license for driving light duty vehicle and are not in possession of a driving license for heavy duty vehicles on the last date of submission of application pursuant to the recruitment notification in question. The respondents have rejected the candidature of the petitioners for the reason that they were not possessing the requisite qualification, that is valid driving license for driving light duty as well as heavy duty vehicles. Full stop. The tribunal, while taking into consideration the above facts and circumstances of the case, has dismissed the OA filed on behalf of the petitioners. During the course of the argument, the lead counsel for the petitioner has frankly admitted that the petitioners, there are three petitioners or one petitioner? only?
Three petitioners, no?
The
petitioners.
petitioners, though were not in position of driving license for driving heavy duty vehicles, as on the last date of submission of application of the recruitment notice in question, but later on in the year 2020, they have possessed, they have acquired the said qualification. They have acquired the said, the driving license for driving heavy duty vehicles. Full stop. The counsel for the petitioner has also submitted that the Western Railway has appointed one Rohit Kumar in the year 2020 on the post of motor vehicle mechanic, motor vehicle driver cum mechanic, who was also not possessing the heavy duty license. Though the heavy duty license. However, in support of the said contention, no copy of the advertisement pursuant to, no copy of the recruitment notification pursuant to the said person Rohit Kumar was appointed and no other details have been provided. Full stop. Learned counsel for the petitioner has also placed reliance on the decision of the Honorable Supreme Court rendered in mention these three judgments. However, we are of the view that the same has no applicability in the present case, because those cases belongs to admission in the degree course, in relation to issuance of tenders for running a running restaurants at International Airport, Bombay, and in relation to the employment of in relation to appointment in the Eastern Railways on the basis of a order passed by the Allahabad High Court, which has attained finally. In such circumstances, we don't find any merit in this petition. The same is therefore dismissed. Yes, the concept for the state of Sikkim.
Password meter 5.
Online. Lord, we assisted the council for the state of Sikkim by giving the link to appear online. They have no. Nine.
Is located in Guwahati or?
No, the local council, Mr. H. Buragohai, he is out of station,
Okay.
although his name has been shown. And the Sikkim council, they are supposed to appear online, my lord. We have assisted them by giving the link and all, but they are not turning up, my lord.
He was there. Who is that
Advocate
in Sikkim?
Jung.
The additional age.
additional AG, Mr. Jangpo. Yes. Phone করে দিন, ঘুমাবার কারণে।
Because earlier we granted time to
Yes, my lord.
this appearing for the state, the time for filing this the counter to the.
I,
But no reply.
no replies. In fact, my lord, since the counsel for the respondents have said that they don't want to file reply.
No, that private response.
Private respondent, my lord. In fact, in the writ petition, my lord, in the order of the single judge, there was no relief sought against us. There was no direction against us. In fact, yes,
Order, but let the state of Sikkim may file their replies.
it appears that the state of Sikkim is not very interested.
They appear that will grant them a last opportunity. Only.
Fine, my lord. I'll just try, my colleague has gone to my lord.
First, for the timing, let him come.
Yes, my lord. Much obliged.
Item 19.
Wait, please, Your Lordship. Lordship, this writ is directed against the judgment order dated 3rd of April 2025 of the single judge, my lord. My lord, we are aggrieved. I am aggrieved, my lord, by the denial of promotion from grade C to grade D in Oil India Limited, my lord. My lord, the basis of this promotion, my lord, is a selectivity ratio and an application of a concession to SC/STs. If my lord comes to page 88, my lord, my submissions would be on two legs, my lord. If page 88, my lord, comes to,
Yes.
my lord sees 2.6, this is the promotion policy of 2016, my lord. 2.6, my lord, composition of the DPC.
Yes.
My lord, just below the table, Lordship will see concession to SCs and STs in posts filled by promotion by selection will be regulated by DPE OM number so-and-so dated 31/01/2014 or as amended from time to time. My lord, this office memorandum, my lord, is, my lord, at page 139. But just before coming to this office memorandum, my lord may come to page 134, my lord. This is the office memorandum of 25th of April, 1991. Which is the precursor, one of the precursors of the office memorandum of 2014. Page 134, my lord. It's a folded page. This is 25th April 1991. This, my lord, is of the Department of Public Enterprises, my lord, circulating the presidential directive in matters of reservation for SCs and STs. My lord may come to the next page, page 135. Towards the bottom of the page, my lord, clause 14. Promotion by selection within Group A, Class 1, 14.1, my lord. In promotion by selection, 2 posts within Group A, Class 1, which carry an ultimate salary of rupees 2250, revised to rupees 25700 per month or less, there is no reservation, except a concession, namely that scheduled caste, scheduled tribe officers who are senior enough in the zone of consideration for promotion so as to be within the number of vacancies for which the select list has to be drawn up would be included in that list, provided they are not considered unfit for promotion. Their promotion in the select list would, however, be the same as assigned to them in the Department Promotion Committee on the basis of their record of service. They would not be given for this purpose one grading higher than the grading otherwise assignable to them on the basis of their record of service. So and so. Now, my lord may turn to the next page, my lord, page 137. This is another office memorandum, 8th November 2004. My lord, this is also on the same lines. Only difference here, my lord, is that the pay scale has been raised to an ultimate salary of rupees 5,700, which is revised to rupees 18,300 per month. The rest remains the same. Now, my lord may come to the office memorandum mentioned in the policy at page 139. 139, my lord.
Yes.
This is 31st January 2014. The undersigned is directed to refer to Department of Public Enterprises OM number so-and-so dated 8 November 2004, which Lordship has read on the subject mentioned above, and to say that consequent upon implementation of the 6 Pay Commission recommendations, DOPT has issued OM number so-and-so dated stating that new ceiling for concessions in case of central government employees would be carrying a grade pay of rupees 8,700 or less. Since no equivalence can be established between CDA scales and IDA scales, more so because many scales have been merged into 4 pay bands under CDA pattern, the earlier grade identified in 2004 for CPSC employees, that is E5, may continue to be the reference post for the purpose of implementation of concession to SC/SC employees and posts filled by promotion by selection. Now, what is this grade E5, my lord? Up to grade E5, since there is no equivalence, my lord, between the central dearness allowance and industrial dearness allowance, my lord, they have identified grade E5 in IDA, my lord, and the Central Public Sector Enterprises to be the grade to which this concession would be applied. Now, this grade E5, my lord, at page 140 is the office memorandum, my lord, which, my lord, gives the pay revision for employees. Page 140, my lord. The revised pay scales, Lordship will find that clause 2 of this, my lord, at page 140. Revised pay scales, the revised pay scales.
Single judge is simply denied you the relief on the ground that you are asking a benefit under the policy document of the year 2021. Whereas the promotion was admittedly given under the policy of 2016, where no such benefit was there. This is what the single judge has done.
My lord, that was the second leg of my argument, my lord. The first leg, I have also submitted a written note, my lord, as directed by the single judge in the single judge proceedings, in the writ proceedings, my lord. My lord, the first leg of my submission, my lord, which is not recorded, my lord, in the judgment, my lord, is that this concession cannot be applied for promotions from grade C to grade D. That is what I was trying to impress upon Lordship. It was not addressed, my lord, though. My lord, we had given a note, my lord, and the person has already retired, my lord. My lord, at that time, my lord, it was argued, my lord. It was argued. I understand, my lord.
Simple clarification.
My lord, the person has already retired in the meantime.
Already retired.
Already retired, my lord. He will only get the benefit, my lord, of the fixation, my lord.
And but
My lord.
no need to issue but we are already
Deeply obliged. There are
I am
few,
for respondent 1 to 6, Lordship, and there are private respondents.
some private respondents.
Private respondents also do.
private respondents are also
Yes.
there.
My lord.
They are also served.
My lord, it has come up for the first time,
First
my
time.
lord.
I am for respondent 1 to 6, and notice may go.
For the petitioner. We are of the view that matter requires consideration, admits. Mr. So-and-so put an appearance on behalf of so-and-so. Let notices be issued to the other respondents. 8 weeks. Registered AD and Dusty. Requisites if admitted law on the. Yes.
Hello.
Deeply obliged.
Item 20 and 21.
May it please the Lord.
This matter had come up on the last occasion, my lords. By consent, we had taken today's date. But in the interregnum, what had happened, my learned friend, senior counsel, probably was supposed to go and meet his daughter. So there was a request, my lords, put to us, my lords, that the matter might not go on. So I had rescheduled my hearing dates in the Supreme Court, my lords. So if this matter, my lord, I'm ready with the arguments. There is no difficulty. I was ready the other day also, my lord. If your lordships could keep it next Monday or on the 2nd, my lord, I'll be really grateful, my lord. These are certain legal issues are there that I would want to come physically and assist your lordships, my lord. It is only for that endeavor, my lord, nothing else.
Which date you are asking?
My lord, any date on any Monday going forward, my lord.
My lord, can I make on submission? I can do my part, my lord.
Here, both of you.
But in that case, on Tuesday, not on Monday, my lord. Monday.
Very well, my lord. Lordships will have it on the
Tuesday
next.
is a hearing day.
Hearing day will not be.
On Wednesday, my lord.
Wednesday.
Not Wednesday, my lord. If it Tuesday, my lords, if it's not inconvenient, my lords.
Tuesday, not possible, sir. It's a hearing day.
Then on the third, my lords, if it's possible, third,
Third of June.
yes, my lords.
Then the 3rd of June is a
Saturday, sir.
Tuesday.
Third is not working day.
Fourth,
Sorry, third, acha. Fourth, we can have in fourth or this.
fourth is okay. my lord.
Sixth.
Fourth is
or
okay.
sixth.
Fourth, my lord.
Fourth, my lords. Fourth is better.
At the request of the learned counsel appearing for the respondent number.
2 and 3.
I'm appearing for 2 and 3.
In both the petitions.
No, my lords, in the other petition, my lords, I am for respond number 6.
In this writ petition number, sorry, writ appeal number. At the request of the learned counsel appearing for the respondent number 2 and 3 in writ appeal number 5/2025 and for respondent number 6 in writ appeal number 388/2022. List this appeal for admission. Yeah, list these appeals for admission on 4th of June.
Fourth. I'm so grateful, my lord.
Item 22.
That will be lost. This case is relating to promotion from,
After retirement.
yes, after. Lordship, in fact, the case was arisen while I was in service.
Sir, the Supreme Court has clearly said that.
Well,
After retirement, no promotion.
my lord,
When,
in fact,
particularly
Lordship,
when
that
no
was,
junior to you was promoted.
my lord, it was on the fault of the respondent authorities. If they could have correctly.
That maybe for that fault. If no person junior to was promoted and this, till that promotion exercise is made, you are superannuated, no relief can be granted, the settled law is there.
My lord, I am relying the judgment of the Honorable Supreme Court.
Yeah, when they said that even though after retirement also.
Yes, Lordship, there is a judgment, Lordship. There, Lordship, kindly peruse that just 3 judgment and 2-3 paragraph, Lordship.
Okay, now.
Petition के कितनी अच्छी लगी? Petition के होगा.
Let first judgment, your Lordship may kindly take 2007, 6 SCC 524. My lord, paragraph 4. May I read, Lordship? Learned counsel for the state has submitted that grant of retrospective benefit on promotion cannot be given to the incumbent when he has not worked on the said post. Therefore, he is not entitled to any benefit on the promotional post from so and so. In support thereof, he has relied some citation. And so and so, my lord, we have considered the decision. We have considered the decision cited on behalf of both the sides. So far as the situation with regard to monetary benefit with retrospective promotion is concerned, that depend upon case to case. There are various facets which have to be considered. Sometimes in a case of departmental inquiry or in criminal case, it depends on the authorities to grant full back wages or 50% of back wages, looking to the nature of delinquency involved in the matter, or in criminal cases where the incumbent have been acquitted by giving benefit of doubt or full acquittal. Sometimes in the matter when the person is persecuted and he has been challenged the same before the court or a tribunal, he succeed in that, and direction is given for reconsideration of his case from the dead person junior to him were appointed. In that case, the court may grant sometime full benefit with retrospective effect, and sometime it may not. But next important, particularly when the administration has wrongly denied his due, then in that case, he should be given full benefit, including monetary benefit, subject to where to there being any change in law or some other supervening factors.
However, it is very difficult to set down any hard and fast rule. The principle of no work, no pay cannot be accepted as a rule of thumb. There are exceptions where courts have granted monetary benefit also.
So the court has carved out two exceptions. One where some criminal proceeding or departmental proceedings are
Yes,
there.
that
then
is-
only- Then he is entitled for all the benefits, or where juniors to him has been promoted or granted benefit, then only the benefit can be given. Here in your case, the juniors have not been promoted. You are saying there was 7 vacancies in the year 2010 and they have not considered me for those vacancies, and therefore now grant me the said relief. Sir, how can we, that is altogether contrary to the settled law by the Supreme Court, sir.
My lord, yes.
Once you are retired and there is no case that any junior to was promoted, can't get this benefit.
My lord, super particularly where the lordship, this line is
That
concerned.
is, the-
My lord, in fact, lordship,
Sir, the judgment you have to read the judgment as a whole.
my lord,
They have carved out two exceptions.
yes, lordship.
That is not fair in your case.
My lord, in my case, the landed citizens are basically relying in the Amal Satpati case. In that case, lordship, that is distinguishable case. Because in the West Bengal, there was a service rule. Providing that there is a bar lordship in providing retrospective promotion. And that appellative in second, that in that case, lordship, when the government has accorded approval, on that day he was not in service. Prior to that, he retired. But here in this case, lordship, the appellant lordship on the day of notification, when the promotion is effected, he was in service.
That's all.
And second lordship, I have in paragraph lordship in 2015.
Yeah.
14 HCC 335 lordship paragraph 14 and 15.
14 and 15.
Paragraph 14 and 15. In normal circumstances, when retrospective promotion are effected, all benefit flowing therefrom, including monetary benefit, must be extended to an employee who has been denied promotion earlier. So far as the monetary benefit with regard to retrospective promotion are concerned, that depend upon case to case. In so and so case, that principle of no work, no pay cannot be accepted as a rule of thumb, and matter will have to be considered on a case to case basis in paragraph so and so. My lord, one paragraph, lordship, in that case has quoted here. My lord, paragraph 15, your lordship, kindly. We are conscious that even in absence of statutory provision, normal rule is no work, no pay. In appropriate cases, a court of law may.
Please come to the facts of the case, sir. What are the facts? What are the facts?
My lord.
You are relying on this judgment. Facts kya the is case ke? Challenge in this appeal to the order of the High Court, Delhi, dated so whereby the High Court dismissed the writ petition filed against the order of denial of pay and allowances to the appellant for the period of itna till date of his actual promotion, and also order dismissing review application. So that is altogether a different.
Well, if-
You were promoted on a subsequent date, you were claiming pay and allowances for that. That was allowed. How this is not at all.
Well, so far the ratio laid down in this
Not
case.
ratio is the court took into consideration the no work, no pay rule, and thereafter they have passed this order.
My lord, in this case also, although the petitioner,
Other judgment.
my lord, in 1997, there is a full bench decision.
Yes,
Lordship, paragraph 22, 24, 25, 26, and 27.
but what are the facts of those cases?
My lord.
The resolution matter. This is a reservation matter.
Well, reservation matter, but
They earlier judgments of the Virpal Singh Chauhan, Ajit Singh, State of Punjab, that is in relation to OBC reservation.
kindly see the paragraph, what is quoted in the paragraph 22. 22 and
Okay.
Article 14 and Article 16(1) are closely connected. They deal with the individual rights of the person. Article 14 demand that the state shall not deny to any person equally before the law or the equal protection of the laws. The Article 16 so is positive comment. There shall be equality of opportunity for all citizens in the matter relating employment or appointment to any office under the state. It has been held repeatedly by this court that clause so and so is a facet of Article 14 and it takes its root from Article 14. The said clause particularly the generality in Article 14 and identities. In a constitutional senses, equality of opportunity in matter of employment and in the appointment to any office under the state. The word employment being wider, there is no dispute that it takes within its fold the aspect of promotion to the post above the stage of initial level of recruitment. Article 16(1) provides to every employee otherwise eligible for promotion or who comes within the zone of consideration a fundamental right to be considered for promotion. Equal opportunity there here means the right to be considered for promotion. If a person satisfies the eligibility and zone of criteria but is not considered for promotion, then there will be clear infraction of his fundamental right to be considered for promotion, which is his personal right. Malat, here lordship, the petitioner lordship, he was eligible and his case was recommended by the.
So any person junior to the petitioner was promoted. There is the question of the violation of Article 14. You are claiming that in the year 2010, there were anticipated vacancies, and on those anticipated vacancies, the government has not granted you promotion. In the meantime, you retired, and the promotional exercise was carried out after your retirement. So you're saying that since those vacancies were there, so you should be granted promotion even after your retirement.
My lord, they have clearly violated the statutory provision. As per provision lordship, the authorities should, my lord, could have assessed the likely number of vacancies for the whole year. They cannot, the whole year means lordship here from 1st January to 31st December. But they have determined the vacancies up to 35/2010. And there, after that lordship from 1/6/2010 to 31st/12/2010, that vacancies were not considered. In the event that vacancies could have considered lordship petition, this appellant could have been promoted at the time of his lordship employment in service. If your lordship kindly see the rule, Assam Civil Service Rule 1998, Rule 12. They have violated this provision.
That's all.
My lord, provision, rule 12 of Assam Civil Service Rules 1998.
Determination of vacancies.
Yes, that is
So
determined.
initially they determined 17 vacancies, but in addition to that, 7 vacancies are also to be taken into consideration.
Yes, 7 vacancies were there.
Those they have not taken into consideration,
Yes,
and therefore, despite your position in the gradation rate at serial number 26, you were not provided appointment,
no,
promotion
my lord,
against those 2010 vacancies.
yes,
And they carried out the promotional exercise only in the year 2012, though you have retired on 31st of December 2011.
my lord.
So now you are claiming that considering that situation, now you should be accorded promotion even after your retirement.
Yes,
This is what the case is.
my lord, although my position was 26, but it will come to 22.
22 because 2 of the persons
Yes,
have
sir, 4
already
persons.
retired or some died or something else.
Yes,
Ultimately 22, and if 17 plus 7, 22 comes.
and in the event lordship, if the promotion of the appellant was not considered in the year 2010, they could have considered for the year 2011. That was also not done. Because 2011, he retired on 31st 12 2011. He had got the whole period of for the year 2011.
That's all.
My lord.
This petition, this writ appeal is filed by the being agreed with the order dated 17/2/2025 passed by the single judge in writ petition number 6318/2019. Stop. The petition, before the writ court, the petitioner has prayed for the following reliefs. Para number 49, page number 49, the writ relief. The reliefs of the case are that appellant, then the petitioner that the appellant was recruited to the Assam Civil Services in bracket ACS class 2nd cadre on 2577. He was promoted to the ACS senior grade 1 cadre later on. This ACS class class 2nd cadre on, he was recruited Assam Civil Services ACS class 2nd cadre in the year 77. Later on, he was promoted to ACS in bracket class 1 and also promoted to the post of ACS senior grade 2nd in the year 1997. The next promotional post on which the petitioner, on which the appellant could have been promoted was ACR senior grade 1 cadre. The case of the petitioner before the learned single judge was that the action of the respondents of assessing the vacancies of ACS senior grade 1 for the calendar year 2010 was erroneous. The appellant has contended that the respondents have assessed 17 number of vacancies for the year 2010 for cadre of ACS senior grade 1, whereas 7 additional vacancies have not been taken into consideration, which would have arisen during 1/6/2010 to 31/12/2010. The appellant has projected that he was placed at serial number 26 by the selection committee in order of preference in the select list prepared by them for the purpose of granting promotion in the cadre of to the cadre of ACR senior grade 1. However, there were persons whose cases were not considered for want of ACRs. And in that case, the petitioner, the appellant would have been placed at serial number 22. It is further projected by the appellant. If those additional 7 posts falling vacant to the cadre of ACS senior grade during the calendar year 2010 were included, the appellant would have been promoted to the cadre of ACS senior grade 1. But the respondents have not undertook that exercise, and therefore the promotion, therefore the petitioner was denied the benefit of promotion illegally. The learned single judge, after heard the learned counsel for having heard the learned counsel for the parties, and after taking into consideration the fact that the appellant superannuated from the services on 13/1/2012, to 2011, whereas the exercise for filling the promotional posts of ACR grade 1 were carried out by the selection committee on 27/3/2012. The relief claimed for by the appellant in the petition cannot be granted. The learned single judge has the relevant portion of the impugned order passed by the learned single judge is reproduced here under para number 12, 13, 14, 15, and up to end. Learned counsel for the appellant, while assailing the impugned order, has placed reliance on the decision of the Honorable Supreme Court rendered in is Ajit Singh and others versus State of Punjab, 1999, 7 SCC 209, 2007-6 SCC 524 and 2015. 2015, 14 SCC 355 in their title note. Having gone through the above referred rulings, we are of the view that the same has no application in the case of the appellant, as the Ajit Singh's case, as the case of Ajit Singh Supra is in relation to the reservation. Reservation in the service, reservation in the employment, whereas the other two judgments, State of Kerala, Supra and Dilip S. Mukta and Ramesh Kumar Supra are on the point of principle of no work, no pay. We are of the view that the learned single judge has not submitted any illegality in passing the impugned order in the facts and circumstances of the case. Hence, no case for interference is made out. The writ appeal is dismissed.
Well, another important aspect was there in this case, Lordship. There are some officers, Lordship, who after retention, they got the benefit.
That was illegal. They
Okay.
granted that was the illegal.
Item 23.
Lordship, in this matter, Lordship, the petitioner challenged the wires of the recruitment loads, Lordship. So in this matter, the learned AG was appearing, Lordship.
When?
Lordship, today is out of station, Lord. Next week, after 27th, Lordship.
But this matter pertains to Itanagar bench, my lord. If Lordship permits, it can be transferred there also, because
Application with the registry will pass it on.
my lord. My lord.
Lordship.
Why it was then filed here?
At that time, there was no division bench, that's why I moved here, my lord. Initially, at that time, now there is a regular.
It was not available.
At that time, at that point of time, my lord.
2016.
16, my lord.
Move an appropriate application.
My lord.
List after 4 weeks.
Obliged.
This concept of the state of Sikkim. नहीं है available. You had a talk with
My
them?
lord, I believe they are online, my lord. Due to, I think, connectivity problem, they are not able to, but I believe they are online, lordship.
Yes, Mr. Consul. Yes, Mr. Consul, why you not file response to the application? You are not audible, Mr. State Consul, you are not audible.
But we have no response to file, my lords can.
So we'll allow them. We'll allow their IA.
Please, my lords.
My lord, my only submission, my lord. May I please, my lord? My lord, though I have not filed my written response, my only submission is since respondent numbers 21 to 24 is claiming benefit as per the impugned judgment, as per paragraph 23 and 28(5) of the impugned judgment, my lord. So in view of that judgment, my lord, since there is no stay, if they are claiming benefit in view of that judgment, my lord, we the respondent also, my lord, we may also be given benefit on that particular judgment.
Either you move an application. At present, we are in consideration of this application and nothing else. If you want some benefit out of that order.
Yes, yes, my lord.
We are not.
My lords, may I submit, my lords? My lords can kindly fix a date where we can come and argue the matter, my lords. It will be.
Where is the? We are simply considering this application. You have no objection to the application. We'll allow this application. That's all.
But
No, my
I
lord,
would.
my objection, my written, I wanted to argue, my lord, but if My lord is
Madam,
inclined to
just
allow
now,
that.
on the first time, when the matter was first taken up today, you
Yes,
said
ma'am.
you don't want to file any response to the application.
Yes, my, I
And
wanted to
immediately
argue
granted.
verbally, my lord. My lord, I may be given some time, my lord. I wanted to argue verbally because
Madam,
they are,
whether by giving this direction or allowing this application, your rights are going to be affected or not,
yes, my lord. Because
then why you
if
have not
they are-
filed the written response?
because my lord, they are taking benefit of the impugned judgment. That impugned judgment is
Madam,
benefiting us also.
why we have not countered to file any counter, then argue it out without counter. Argue
Yes,
it out.
my lord. Yes, my lord. That is what I had submitted, my lord. I wanted to argue, my lord, without giving the
Argue
reply.
it out. Now
Yes,
argue
my
it
lord.
out. Yes.
Yes, my lord. My lord, in this application, my lord, they are taking benefit purely on the ground that, my lord, may I take your, my lord, to the relevant page of the judgment in which they have annexed along with the IA, my lord. May I take, my lord, to page 108 of the IA, my lord.
নেট চলে না ওই আমরা আমি যখন কবে voice on too.
You are the respondent's number?
Respondent number, my lord, 4, 5, and 6. Before
4,
the
5, and 6 in the
writ petition.
Before the writ
Yes,
petition.
yes.
Your this promotions were not interfered with by the learned single.
No, there was no direction against us also. And we were promoted, and that promotion was withheld on the opinion of the council for the state, saying that there will be contempt proceeding and it will have adverse consequences, writ appeal is pending, all these things has been said. And thereafter, our promotions were withheld, my lord.
So, madam, you are for the original petitioners?
Yes, my lord. Yes, my lord.
So, whether you have challenged this order passed by the learned single judge by way of appeal?
No, my lord, I have not
In
challenged.
relation to the respondent number 4, 5, and 6?
No, my lord, I have not challenged, my lord.
Then how you are aggrieved by this now? How you can
No.
challenge
My lord, my respect, yes, my respectful submission, my lord. I am not stating that they are not seniors to me. They were seniors to me, my lord. But the only grievances is since they have moved an IA, taking benefit of that particular judgment of the single judge, referring to paragraphs 23 and 28(5), stating that the court has stated that there is nothing to be stated with regard to respondent numbers 4, 5, and 6 by highlighting on certain aspects, my lord. And in the same judgment, my lord, in the same judgment at paragraph, because the learned counsel for respondent number 21 to 25 have highlighted only paragraph 28(5), clause 5, but paragraph 28, clause 1 to 4 also states that the respondents are to be given, the present respondents are to be given benefit of seniority, and the respondent among 1 to 10, whoever has retired, they shall be getting retrospective effect. My only grievances is here, my lord. The appeal has been filed.
Madam, you
Yes,
just,
my lord.
in the, before the writ court,
Yes, my lord.
you have claimed seniority over the respondents.
Yes, my lord.
Over the respondents on the ground that you were retained on officiating basis since 2008, and you are deprived from the regular promotion in which some other persons were granted.
Yes, ma'am.
You have also challenged the with the promotion of the respondent number 4, 5, and 6.
Yes, my lord. Yes, my lord.
The single judge, while allowing your writ petition, has refused to interfere with the promotional exercise of respondent number 4, 5, and 6.
Yes, my lord.
You
Yes,
have
my
not
lord.
challenged that finding by way of filing an appeal.
Yes, my lord.
Now, these persons who promotions were not interfered with, they are entitled for further promotion on their as per their seniority. What's wrong in that?
Yes.
It's going to be affected when you have not particularly challenged their promotions. Of the learned single judge, whereby their promotions were not interfered with.
Yes, my lord. That is there, your lordship.
That is what.
Yes,
Then
my lord.
why you are arguing here?
My lord, my only submission is because that judgment has given us benefit even in that paragraph 26,
Get that
27, and
benefit.
28, my lord.
You'll get that benefit. How your benefit are being affected with this leakage? This IA is preferred on behalf of the applicants. With the prayer. Verify that the tendency of the writ appeal, this writ appeal will not come in the way put an embargo /bar for the Department of Personnel, Government of Sikkim for effectuating the promotions of the applicants to the post of additional director in selection 1 of the Sikkim Finance and Account Services. That is from 14 to 2023, as has been granted by the office order dated 14 to 2023. Followed by the consequential grant of promotion to the post of director, that is from 15 to 2025. Full stop. The promotion of the petitioners of the applicants came to be challenged by the private respondents before the Sikkim High Court by way of writ petition number 30 of 2016. The learned single judge, while allowing the can we get the promotion of the petitioner? Along with the promotion of other respondents, that is respondent number 7 to 17 in the writ petition. Stop. The learned single judge, while allowing the writ petition filed on behalf of the private respondents, has interfered with the promotion of the other respondent except the applicants who were included as respondent number 4, 5, and 6 in the writ petition. The learned single judge in the operative portion of the impugned judgment has observed as under. The page number 1116, para number 5 as Roman. You can. The respondent, the applicants are contending that though the promotion of the applicants was not interfered by the learned single judge, and they were promoted to the post of additional director in selection grade 1 of the Sikkim Finance Account Services, that is from 14 to 2023, followed by consequential grant of promotion to the post of director, that is from 15 to 2025. But in effect, those promotion orders were not given any effect to as per the opinion given by the government council.
Yes, my lord, that one, page 126, additional AG.
Additional AG of the Sikkim, state of Sikkim. Learned counsel for the applicant has submitted that when the promotions of the applicants on the post of, which post it was?
It was the post of additional director, my lord.
No, earlier, when this was put to challenge.
This is senior accounts officer, my lord.
When
Senior
on the post of
senior accountant, my lord.
senior accountant accorded to them in the year 1997 has not been interfered with by the learned single judge. They, the applicants are entitled for further promotions as per their seniority on the posts of additional director grade 1 and
Additional director in the selection grade 1 at level 20.
Selection grade 1 at level
20.
And for further promotion on the post of director. Full stop. It is contended that when the promotions were already granted, there is no reason for the state not giving effect to those promotions. Full stop. No counter to the application is preferred by the private respondents as well as the state of Sikkim. Both of the council for the private respondents as well as the state of Sikkim has stated that there is no requirement for filing any counter to the to this IA. Full stop. Taking into consideration the overall facts and circumstances of this case, particularly the fact that the promotion of the petitioners on the post of senior accounts officer accorded in the year 1997 has not been interfered with by the learned single judge. There is no justification on the part of the state of Sikkim not to give effect to the promotions accorded to the applicants on the post of additional director grade 1, additional director selection grade 1, first
Grade 1.
in scale of 22.
At level 20, my lord.
At level 20.
Yes.
At level 20 and on the post of director. Hence, the application is allowed, the relief rate for the IA number so and so is granted. Yes.
My lords, may I mention?
Much of.
My lords, if this matter can be fixed in any day in the month of June.
Today it is only for the IA.
My lords, we are outstation council, so we can come to the court on a fixed date. My lords, if my lords pleases.
Please ask this local council to have a date from the registry. Yes.
For hearing,
Much.
Grateful.
item 27 and 28.
My lord, here, yes, my lord, we have got the proposal. It is under active examination in the finance department.
How many days?
My lord, let it be after 2 weeks, my lord. In between, it will be done, my lord. Whatever is the outcome, I will place it, my lord. I have got a communication, my lord.
Learned council appearing for the finance department has submitted that the fresh proposal sent by the High Court on 24/2025 is under active consideration of the state government and it is expected that a decision on the said proposal will be taken within a period of 2 weeks.
That's it.
Within a period of 2 weeks, just after 2 weeks.
My lord, may I kindly give a date, my lord?
Date June में date तो कोई
16th of June.
17. Yes.
16th or 17th?